Some types of evidence that you can use in responding to motions for summary judgment. Brought to you by T. Rex Hogan at LegalSelfDefense.biz. Black belt training for people being sued by debt collectors. If you are fighting a motion for summary judgment, you will need to present evidence to the court. So what is evidence, and how do you get it in front of the court properly? First, every state has its own rules regarding evidence. While they can be different, usually they are very similar. You can find your state's laws by Googling your state and rules of evidence. And when you do that, you're either going to be referred to different decisions in case your state has not codified the laws of evidence, or it will refer to some collection of rules of evidence. But in general, both documents and testimony can be evidence. Your own testimony is evidence, for example, but it must be sworn to under oath. To do this, you will need to create an affidavit. An affidavit is a sworn statement. Affidavits have to be based on your own knowledge and observation, and they must be notarized. Your bank will almost certainly have a notary public that you can use for this purpose for free. The testimony of other people is also evidence, and it also must be sworn to under oath. If the witness is friendly to you, then this can be done by affidavit. If the witness is not friendly, you can take his or her deposition. And if the witness is a party to the lawsuit or is an employee of a party, you can use interrogatories. Interrogatory answers are evidence, and that's one reason I emphasize in my litigation manual how important it is to ask good interrogatories, and also to follow up and make sure you get good answers. The other side's responses to requests for admissions are evidence for you. They're not sworn to, but they're taken as true. Your responses to their requests for admissions are evidence for them. For all testimony, you must include proof that it is admissible under the rules of evidence. This means for interrogatories, for example, you should put the entire question and answer and the affidavit page as part of your exhibit. Documents can also be evidence, as I said before, but they must be authenticated. You authenticate documents by attaching testimony, either an affidavit form or otherwise, or admissions that establish that the document is what it is and that the words on it are true. The person testifying must actually know how the document was created, what it says, and, when applicable, other requirements of the business records exception to the hearsay rule. Debt collectors frequently will include affidavits and documents where they have no basis for knowing how the document was created or what it says. For example, they may include documents created which purport to show what the balance of your credit, what the balance of a credit card was during some time before the debt collector owned the debt. Obviously, they don't have any idea about the information that was provided to them by some other party, and that's not a good affidavit. So here's an example of a good affidavit. If the document is a document that you received, let's say you're trying to prove you received a threatening letter or a letter falsely or deceptively stating something, your affidavit would need to include the facts that you received the letter in an envelope addressed to you with the debt collector's address on the return address, that you received the letter on the date, whatever that date may have been, and that you read it and felt threatened. It would not need to include the fact that the information was not true, obviously. Or if, on the other hand, you want to show that you sent a cease and desist letter, that's a letter which tells them to stop communicating with you, you would attach a copy of the letter as an exhibit, and to that you would add an affidavit. Your affidavit would say that the copy is a true copy of a letter that you wrote and that you sent it on a particular date to the debt collector at the address it showed you as its address. Remember that in court, opinions are not facts. Testifying that a debt collector was mean, for example, will probably not establish any fact. Testifying that the debt collector raised his voice and called you specific names or made certain threats will state the facts. Try to keep your statements confined to the facts rather than going into arguments or complaints. For example, you could say, I received the letter attached as Exhibit B on June 13th, 2010. It was signed by John Doe. I believed he was threatening to put me in jail. I called John Doe at the phone number he had left me before, and he said I was damn right. He was going to put me in jail if I didn't pay him. Those statements are all evidence. So is, I began to have trouble sleeping and nightmares of being put in jail. I lost 15 pounds in the next 3 weeks and went to see a doctor about it. But saying, John Doe should be put in jail, or John Doe must be a monster to do that to me, or any other criticism or complaint about the debt collector are not statements of fact. They're either arguments or opinions. And as a general rule, and particularly in motions for summary judgment, the courts are not interested in your opinions. You need facts to prove your case in a motion for summary judgment. You can find help in defending yourself. Go to legalselfdefense.biz. Black belt training for people being sued by debt collectors.